Here is Kavanaugh from before.
What's the remedy?
Well,
do you throw out those votes? Because if you do, some of those voters might say, oh, I actually would have voted earlier if I had known. I'm just trying to figure out how that would play out.
So I think that would be the right remedy, and I think that's kind of a nightmare scenario for exactly the reason that you point out. And I don't think there's any reason for the standing rules to basically say that you have to decide all these issues in those nightmare scenarios, or even in the very closest districts. And the point I was trying to make is, like, if you think about this case proceeding past the pleading standard, the idea that you would have, like, competing experts come in and say, you know, Congressman Bost is kind of a lousy candidate, so this one's going to be pretty close. And that would be my expert, because I'd have to show that the election is close in order to have standing. And then they'd come in, and their expert would say, no, Congressman Bost is the best candidate there's ever been. He's going to win this thing in a landslide.
Well, would you agree to a rule like this one, which sort of makes this question of do you have to show you would win or do you have to show margin of victory a little bit irrelevant? That what you have to show something. It's not enough to just walk in and say, hi, I'm a candidate and I'm suing. But what you have to show is some kind of substantial risk or substantial likelihood, whatever the phrase may be from our standing doctrine, that the new rule puts you at an electoral disadvantage relative to the old rule. So that, you know, if the new rule says more mail-in ballots, then you just have to plead that that's a kind of rule that puts you to an electoral disadvantage. And say something, not a lot, but something to suggest that that's right.
So I could live with that rule. I don't know that it's the ideal rule. I mean, I'm not coming in here asking for a broad rule because I'd like to win this case in the hardest possible way. I'm asking for that because I actually see advantages to it, namely that even under your view, you still, in theory, would have at the summary judgment stage this, like, debate in Article III courts about whether late arriving ballots help Republican candidates or Democratic candidates. And that makes me sufficiently uncomfortable that I actually would prefer a rule that says, no, Congressman Bost is coming in and he's saying there are going to be unlawful votes cast and there'll be ballots with his name on it in his election. That's enough. We're done. None of these.
I mean, your rule really does just take out the injury requirement entirely. It just says you should assume that if a candidate is there before the court, the candidate has good reasons for being there before the court. And for the most part, I think we have rejected that view of standing.